Circuit Court is now in session. The Honorable John Brown presiding.
Thank you. Please be seated. Okay, so from shortest to longest, Mr. Cotton.
Hey, Judge, good morning, or afternoon. Byron Cottonwith, and on behalf of Juan Salazar, I believe he's coming out. He's incarcerated. Thank you, sir.
Sounds good. So after Mr. Cotton, we'll do Mr. Rodriguez.
Hey. Judge, if I could just have about 10 seconds.
Yes, sir.
Your Honor, I just need to let him know what I'd spoken with the state about how we're going to be moving forward.
Okay,
I'd like him to hear it from me before he hears it from you.
good.
Judge, we're here, State of Florida, Juan Trevino Salazar, on a VOP case. Your Honor, he also has a new law offense that came out after the VOP. It's a failure to register type of case about vehicles. That is currently set for May 13th. I've spoken with Ms. Berrickman about this case. I think what we'd like to is, rather than having these two court dates running separately, I think originally we were going to maybe do the VOP first. I think we're going to see what happens depending upon what information comes out on witnesses, and we'd like to just put them all on the 13th running together to be able to track at the same time.
Okay.
Is that okay with the court?
Any objection from the state?
No, Your Honor.
Okay. Mr. Salazar, I'll see you on May 13th, okay? Thank you, sir.
Okay. And they'll all be on your 9 a.m., I assume, VOPs and
The
everything?
inmates come in the afternoon, I believe.
Okay, that's right. All right. That's all I have before the court, Judge. Actually, if Mr. Snell and I could approach on one matter, do you
Yes,
mind?
sir. Not a bit.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Man, I've got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Okay. Yes, sir. You're Mr. Rodriguez?
Yes, sir.
Good. Mr. Rodriguez was scheduled for this at 1:30.
Yes, sir. I was apparently in the wrong courtroom.
Okay. Well, I'm glad you made it down here.
Yes, sir.
So the capias is withdrawn for Mr. Rodriguez.
Is this an arraignment?
Yes, sir.
Okay.
Correct. And it's 24, it's number 20 on my 130 docket, 24 CF 510. Mr. Rodriguez, did they give you a copy of the information?
Yes, sir.
Okay. So I'm looking at the charges against you. Does the state have no, it's with intent. Mr. Rodriguez, do you want me to appoint a public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
I would say about 12 to 1400.
Okay, I do appoint the public defender to represent you. Mr. Koch? Mr. Rodriguez is going to be represented by the public defender. It's Evan Rodriguez. It's 24 CF 510.
Okay. And is it showing no information currently filed, Your Honor?
Okay, so 510 there is one, 511 no. Okay.
So, Your Honor, we will be entering a not guilty 4 counts in that 510 case. And I guess keep that set for the 513 pretrial. And for the 511, no information filed, are we going to set Mr. Rodriguez to the next
Yes, sir, a week from today.
week from today?
So, Mr. Rodriguez, I'll see you a week from today on the 24 CF 511 case. And the other case, I'll see you on May 13th.
Yes, sir.
So the,
It may be the same case. That's the reason we're there.
Okay.
Why there's
So,
an information filed on one.
Mr. Rodriguez, stay in touch with the public defender because they can straighten it out for you, okay?
Okay.
Good. Thank you, sir.
that's, call that number to schedule appointment. Okay, keep this. And next week you have court.
Yes, sir.
Okay.
All right.
Yes, sir.
Okay, and then,
I believe Mr. Koch has a plea with Danny Smith.
okay, Mr. Koch.
Your Honor, this is Mr. Danny Smith in 2 cases, the 2023 CF 2411 and then the 2024 CF 521, Your Honor.
Yes, sir.
Your Honor, this will be a change of plea. Now, in the 23 CF 2411 for count 1, count 2, and count 3, and in 24 CF 521, just for count 1, there'll be adjudication of guilt, 2 years of the drug offender probation, which has the curfew from 7 p.m. to 7 a.m. This will be followed by 1 year of standard probation. There's $40 per month cost of supervision, $1,230 in court costs, $250 in defense costs, no alcohol, no drugs without a valid prescription, substance abuse evaluation and any recommended treatment. There's the 48 hours of community service and must maintain gainful employment or submit 5 job applications per week. Now in the 23 CF 2411, count 4, and in 24 CF 521, counts 2, count 3, count 4, and count 5, it'd be adjudication of guilt and credit for time served. May I approach with plea form?
Yes, sir. Thank you. Mr. Smith, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. Mr. Smith, did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his
I'm
representation?
very happy.
Did you sign the plea agreement?
I did.
Mr. Smith, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served on count 4 and counts 2 through 5. You're sentenced to 2 years probation followed by 2 years drug offender probation followed by 1 year of regular probation. In the other cases, you'll have a 7 p.m. to 7 a.m. curfew. You'll need to pay the $40 per month cost of supervision, the court cost, total of $250 public defender's fee, have no alcohol or any prescription medications without a valid prescription. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Perform 48 hours of community service work. And I think I'm missing something. You will need to obtain gainful employment. Until you obtain gainful employment, you'll need to perform 5 job applications per week.
Yes, sir.
Okay. Thank you, sir. Good luck to you, Mr. Smith.
Thank you very much.
Yes, sir.
Yep.
We also have Danielle Shario
Okay.
from the 9 a.m. docket.
Thank you, ma'am.
Okay. And Your Honor, if I could just have a moment for a signature.
Yes, sir.
Yes, Judge, we have Danielle Shario in 2022 CF 559. Your Honor, it's going to be admit. to the violation, but maintain the withhold. It's 100 days, Okaloosa County Jail with credit for all time served. There'll be a new term of 36 months, and that's the drug offender probation, which has the curfew from 7 p.m. to 7 a.m. There's a $40 per month cost of supervision, no possession of drugs without a valid prescription, no alcohol, random breath tests, random UAs, 24 hours of community service. There's the $100 cost of prosecution, $150 in defense costs, must maintain gainful employment or 5 job applications per week, and there is a substance abuse evaluation and any recommended treatment. If I may approach with plea form.
Yes, sir. Thank you. Ms. Shario, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. You can pull that whole mic down if you will, Mr. Koch.
You can stand right here.
And you're fine. You don't have to raise your hand. Ms. Shario, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Absolutely.
Did you sign the plea agreement?
Yes, sir.
Ms. Shario, I do accept your plea. Adjudication is withheld. You're sentenced to 100 days in the Okaloosa County Jail with credit for all time served. Your prior supervision is revoked and terminated. You're sentenced to 36 months drug offender probation. You have a curfew from 7 p.m. to 7 a.m. Pay the $40 per month cost of supervision. Have no drugs without a valid prescription, no alcohol. Submit to random breath test, random urinalysis. Perform 24 hours of community service work. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. You'll need to maintain gainful employment until you obtain that. Then you'll need to perform 5 job searches, or I'm sorry, 5 job applications per week. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 30 days from
The
today.
probation officer shows me how to do all this, yes?
Yes.
Yes, ma'am, they will.
Okay.
Okay, good question, though. When you're released, you'll need to report to probation, okay?
Okay, thank you so much, very
Thank
much,
you,
sir.
ma'am. Good luck to you.
Good luck,
Thank you.
Danielle. Good luck.
Rachel, who's next?
Judge, I think mine's going to be fairly brief.
Okay,
Ms. Bias, Initial Bias.
yes, sir. And the officer that's on Zoom, is she for the ineffective assistance of counsel?
No, Judge, I believe she's here for Ms. Bias's hearing.
Okay, good, okay,
Yeah, April McDaniel.
yes. It says April's notebook, yes. Hello, Ms. Bias.
Judge, we had attempted back in January to enter the plea, but I didn't realize that her score sheet showed that there was a presumptive prison sentence, and so we stopped ourselves. I'm gonna have her, if you would just please, cross through that date and put today's date. Judge, I'm gonna change the date for myself as well.
Yeah, with the bench. You still have the score sheet, right?
I've got a score sheet.
Okay.
It's the one that shows, yes, sir, 29.775.
Yes,
Yes,
Judge.
I don't know, maybe.
yes, sir.
So Judge, we're admitting the BOP, and initially what we'd asked the court to do after if you accepted the plea would be then to sit it for sentencing. I was able to get Dr. Harper here this afternoon, so we're just ready to proceed, and I think the state's fine with that.
Okay. Ms. Bias, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. So, Ms. Bias, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
Yes, I do have.
Okay.
adult
Are you
issues.
currently prescribed any medication for that?
Yes, sir, I do.
Are they providing that to you at the jail?
Mm-hmm.
That's a yes?
Yes, sorry.
Okay. So, Ms. Bias, if I accept your plea, because it's a plea straight up, a plea to the bench without an agreement with the state, what's the maximum sentence that the court could impose? I'm asking you, and the reason is because of that. What's the worst case scenario? If I said, I'm throwing the book at you, Ms. Bias, you're sentenced to as much as I can sentence you to, what would that be?
That would be my 3 years.
Okay, isn't it 5 years in prison? Is there any cap of 3?
Judge, I don't think the state and I have discussed a cap, but I think what she's thinking is that the minimum score sheet was about 29.7, 30 months. So that's
Okay.
where she,
So Ms. Bias, so you understand the score sheet. You've had time to go through that with Mr. Nopes, correct?
Yes, sir.
And that the court has to find a valid reason to go below that 29.77 months?
Yes, sir, I do.
Okay. So that's the score sheet. That's not the top.
Okay.
That's, according to the score sheet, that's the bottom.
Okay.
If I don't find a valid reason to go below it, what's the maximum that you could be sentenced to? Do you know how many years in
And
prison?
it's, what, 5 years?
Yes, ma'am.
okay.
Good. I just wanted to make sure, because you were talking about those meds, wanted to
Oh,
make sure
okay.
that you understood that.
Yes, sir, I do.
Okay, so you read the plea agreement, you understand it?
Yes, sir, I do.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir, he did.
Are you satisfied with his representation?
Yes, sir, I am.
Did you sign the plea agreement?
Yes, sir.
Ms. Bias, do you understand that if I accept your plea, that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anybody said, Ms. Bias, if you don't enter this plea, you're going to be sentenced to 4 years in prison or any other definite sentence?
No, sir.
Ms. Bias, I do accept your plea. How far did you go in school, Ms. Bias?
I graduated from Niceville High School and then 2 years in college.
Good. I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. Mr. Nopes, as far as sentencing.
Judge, I would call Dr. Harper.
Okay, Dr. Harper, if you'll please come to the stand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you. Please see this. Speaking of the microphone in front of you,
Good afternoon, Dr. Harper. If you would, just for the record, state your name
Dr. Julie Harper.
and what licenses do you hold in the state of Florida?
I'm a licensed psychologist.
Okay. And as a result, did you evaluate Miss Bias?
I did.
And did you write a report in regards to your evaluation?
Yes, I did write a report dated 4/7/2024.
May I approach?
Yes, sir.
Yes, that's my report. Yes.
Yes, sir. Any objection from the state?
No, Judge.
Okay, thank you. Ms. Bias, when I hand this over to the clerk, I've got a copy and I've read it and marked through some of it, okay? Highlight it. Thank you.
Dr. Harper, as a result of your evaluation, did you determine whether or not Ms. Bias is suffering from a mental health issue?
Yes, I did.
And what is that?
She has several conditions.
First is major depressive disorder, which is of a recurrent nature, and that dates back to her childhood. She also has a panic disorder without agoraphobia and attention deficit hyperactivity disorder, her history meaning a different clinician diagnosed her with that disorder.
As a result of your opinion that she suffers from this mental health issues, do you believe, are those related to substance abuse, or are they genuine mental health issues?
No, you can see by the timeline in reviewing her social history, Ms. Bias had evidence of depression at an earlier age, and that's due to family dysfunction, and she was an early childhood abuse victim as well. That started a pattern of low self-esteem that predates her substance use.
Okay.
You can see that in the timeline, she did begin using some substances around the age of 16 when she was in a very permissive environment. And I think that over time she learned to cope with her depression by suppressing it with substance use. But the root is a depressive disorder. And you can see that even in instances when she is abstinent from use, like in an incarcerative setting when she's in the jail, for instance, and having panic attacks. She's got a mood disorder that would include feelings of hopelessness, being overwhelmed very easily, having shame-based emotional reactions, and sometimes suicidal thinking.
As a result of you meeting with her and discussing her history, do you believe that she's amenable to getting treatment and help with those problems?
Yes, I do. I spoke with her at length about the treatments that she's received in the past, both with an inpatient hospitalization that occurred in January of 2023, so that's fairly recently, followed by her description of some very good care in the Santa Rosa County Jail by a caring provider who really bonded with her and took time. I think that was a turning point for her in terms of being accepting of treatment, because first of all, it's a male provider, which given her history of sexual abuse, that broke down a barrier that she had. The second part of that is because her depressive disorder has been shame-based. She finally came to a point of acceptance that help is better for her, and that provider was able to kind of make a bridge for her regarding that. She's also sought care in the Okaloosa County Jail, where she's participating in a group therapy voluntarily, and she's also checked by a counselor named Vince who does her periodic mental health checks.
So if the judge were to decide that there is a mitigating circumstance to which he could ignore the guidelines, what is your opinion or suggestion as to the right things that he should order to make her hopefully successful?
Well, I think the most important thing would be to continue with her mental health psychiatric care. And so she's on an anti-anxiety medication in the jail. It's mild. It's something that could be followed by a regular doctor if she had to seek that, though I do think that care for depression with an antidepressant, if she were in the community, would be better. So she could be ordered to attend a psychiatric evaluation so they get her medication started on the right foot, and then she could follow eventually with a general doctor if her insurance limits her to that because of Medicaid. I think that secondarily, ongoing individual therapy would be really helpful for her. And that's because, as I've testified already today, there's a root of the depression that has to do with her feelings of guilt and shame over not retaining her children. And I really do believe that that is a vulnerability that she needs to address with a counselor. And the only way to do that would be individually, to have someone use cognitive behavioral techniques with her and get her to understand actions and consequences that she was dealing with at the time, the environmental stressors that she had. And I think that would also prevent relapse from a substance abuse issue, and I think it would also help her not to recidivate. I think that if she addressed the root of the depression, it would assist her a lot.
Those are my questions, Your Honor.
Thank you. To the state. Questions for the doctor?
Dr. Harper, I know you had stated that one of the diagnoses was it ADD or ADHD?
You term it attention deficit hyperactivity disorder. And then she has combined type per history.
Okay, and per history, does that mean it was self-reported, or did you review some mental health records with that diagnosis in it?
So she and I reviewed her past history of care, and when she was prescribed Suboxone, or Subutex, pardon me, the provider diagnosed her at that time. So every time you give a diagnosis, the person, of course, is questioned about their symptoms, so they'll self-report them. But then ultimately it's up to the provider to provide the actual diagnosis. So if they don't agree based on self-report, they won't diagnose them.
And under the sources of information contained in your report, were there any previous mental health records that you consulted belonging to Ms. Bias?
No, I requested them, but they were not received in time for this report.
And looking at the forensic clinical interview and mental status examination, that and the trauma symptom inventory were the two tests that you conducted on Ms. Bias?
That's right.
Can you describe how the forensic clinical interview and mental status examination is administered?
So that's the procedure of conducting a psychosocial history interview, where you go through the person's background history by interview. You're gathering information about symptom levels, educational history, substance use. And then you administer a mental status examination, which is a series of standardized questions. It's given as a quick screening measure, a cognitive baseline. There are scores that you can give for things like abstraction, so the ability to pair words together, and to recall things, and you give a score for recall, for instance.
Same question, but for the trauma symptom inventory?
The trauma symptom inventory is an assessment measure that Ms. Bias filled in. Within it is embedded validity measures, so the person is not aware of which questions are the validity measures. And then it also allows the index scores to be scored against a standardized population. So you've got normative data that will allow you the T-score, and then you see if it's in the clinical range or not.
I think that's all my questions.
Mr. Noakes, any other questions?
Nothing further, Your Honor.
Doctor, I've got a few.
Okay.
One, in order to downwardly depart, I have to find that Ms. Bias requires specialized treatment. And before you answer that question, you testified here today, mental health, psychiatric care, and then you were talking about medications, and also individual therapy. But in your report, you noted 4 different things, at least 4 that I counted. One was cognitive behavioral treatment, victims counseling, co-occurring disorders treatment, and attend all recommended substance abuse treatment. How can the court find that those are specialized treatment?
Well, in terms of the victims counseling, that fell under my recommendation for individual therapy. And the person providing those services would be able to review Ms. Bias's history with her and realize that being a victim of childhood sexual abuse has predisposed her to an overly active adrenaline system and panic disorder. And so I think that those are specialized because they would not occur if you just threw her to group therapy, for instance. She needs individualized treatment to address the roots of early depression and anxiety. The 4 different recommendations give you options. Of course, Judge, you can choose if you feel that any of those best match the outcome that you wish for her. I do feel that the mental health disorders are primary. The substance use disorders are a secondary coping mechanism that she used, but she's been abstinent now because she came from Santa Rosa County Jail, and now she's been in Okaloosa. So she's got a pretty lengthy period of abstinence right now that if she were referred into, for instance, an inpatient substance abuse setting, I'm not sure that they would accept her because she hasn't had recent use. If you wish to ensure relapse prevention, I don't think that that's a bad idea at all. Obviously, I put it in my report, but I would say that if you're narrowing down recommendations of things to order, the individual therapy is absolutely essential, as well as the psychiatric care. I do think that she's motivated for treatment and would be compliant if you ordered her to co-occurring disorders. I'm fairly certain that she would do everything that you've asked her to do.
Okay. And maybe the only thing that I underlined, I highlighted different things, but the only thing I underlined was you stated she was not able to complete Keaton. You believe, and you testified that you believe that, especially with the help of Santa Rosa County, that you believe she's at a turning point.
The change was being willing to let her guard down with the therapist there. And I do think that the vulnerability that she had around the time she was attending Keaton was that she was still very much fragile with depression and willing to basically give up some of her stabilization to be in a relationship. And I think, again, she's been in a pretty lengthy period of time without needing to bond like that and fill her depression up with another person. So there are some different, aspects of her environment that are going on now that were not the case then. So that's why I think that there's some differences in her motivation, and is different now, and her emotional needs are a little more satisfied at the moment in that she could withhold, some of that pull to give up her sobriety and stability for another person. And so that's something she's learned through therapy now.
Okay, I think just two more questions. One is, so if the court orders mental health, psychiatric care, and individual therapy, those are broad enough to cover the 4 areas in your report?
Yes, I do.
And then the second thing is, how long? How long would she need that treatment?
Well, my recommendation is that she attend a psychiatric evaluation, because at that appointment, they will be able to get the right medication regimen started, but it wouldn't burden her to have to keep paying for a psychiatrist, which may be very expensive in the community. So at least the psychiatric evaluation. As per, it's hard to say with individual therapy, because that really should be up to the provider to determine when she is satisfied that. I think it might be artificial for the court to say you must attend 3 months or 6 months, because.
Well,
really,
and I'm trying to figure out how long should probation be?
Well,
and make sure that it's long enough to require the help that she needs.
I mean, I think obviously that's in the court's jurisdiction, not as a psychologist to decide, but I think that if she were participating in counseling for 9 months, I think that it would make a great difference in her life.
Okay, do either of the attorneys have questions based on the court's questions?
No, sir.
No, Judge.
May the doctor be released?
Yes.
Yes.
Good seeing you again, doctor. Thank you, ma'am. Mr. Noakes?
I've got one more witness, and it'll be brief via Zoom, and it's April Major
Yes, ma'am.
McDaniel.
If you'll take your microphone off mute. Good. If you'll raise your right hand. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, ma'am. You can put your hand down. Mr. Noakes.
Good afternoon, Major. Just for the record, state your name.
Yes, sir. April McDaniel, Major of Jail Operations at Okaloosa County.
And how long have you been at the Okaloosa County Jail in some capacity?
19 years.
Okay. Do you know Ms. Bias?
I know Ms. Bias and her, in the capacity of her as an inmate in our jail.
Okay. And do you have did you contact me this morning about Ms. Bias?
I did.
Okay.
I did, yes, sir.
And I told you that did you offer to write a letter?
I did do that, yes, sir.
Okay. And I think I told you that I think under the circumstances it needs to be live testimony. So could you tell the judge what you would have written in the letter? What did you want the judge to know about Ms. Bias?
Sure. I would like to let the court know that Ms. Bias has been participating as a volunteer worker in our facility. As a non-sentenced inmate, she can't be compelled to work other than to maintain the sanitation of her immediate housing area. But in spite of that, and without any leverage or incentive that we could offer, she has been willing to participate in a volunteer capacity to help us maintain sanitation and clean throughout the facility. For quite a while now, she's been engaged like that for us. She does a remarkable job. I've always found her to be very positive and polite. She's engages positively with staff and does a great job in the work details that we've asked her to do. She's one of a few inmate workers that can work unescorted in certain areas. She's always engaged in the pursuit of those duties and does a good job. Since she's been with us from October the 10th, 2023, she's not a discipline problem, she's not a management problem, she's compliant with facility policies and rules, and is cooperative with staff.
Nothing further, no further questions.
To the state, questions for the major?
Nope, no questions.
May Major McDaniel be released?
Absolutely.
Yes.
Thank you so much, Major. We really appreciate your time and your input.
Yes, sir, thank you.
Thank you,
ma'am.
Judge.
Yes, sir.
I asked Ms. Bias if there was anything she wanted to say. She didn't give me a clear answer, so I don't know if she does or doesn't, but this is your chance if there's anything you want the judge to know.
Okay, but before you say anything, you have two options. You can either be put under oath or not put under oath. It's up to you.
You can put her under oath, Judge.
Okay. Ms. Bias, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, ma'am. You can put your hand down. Tell me what you want me to know.
Thank you for giving me the chance to speak. I just wanted to basically just say I have made mistakes, and we all do fall short, but I have learned from my mistakes. I am not a menace to society, I feel. I feel that, just like the major was saying, for the past 14 months that I have been incarcerated, I've been a trusted inmate. And not only that, I have been in multiple classes that have not just helped me personally for my mental health, my, trauma therapy and, sexual abuse. It also helps me with the bigger picture for my dependency case, for my child. And in hindsight, that's originally what I'm trying to do, is to get and regain full custody of my son. This is how that all started 3 years ago from that night, and this is what I'm hoping that I can continue doing. So I just wanted to thank you for allowing me to speak, and that's all I have to say.
Thank you, ma'am. Questions from the state?
I have no questions, Judge.
Okay. Mr. Nopes, any other evidence?
Judge, just as a remark that I thought I was completely shocked. Did I come to the jail the other day not to see you, but ended up running into you?
Yes, sir.
Where were you at?
I'm cleaning legal.
But cleaning, what does cleaning legal mean?
So you just whenever the attorneys or whatever, the people that come in to talk to us inmates, you have to clean and stuff like that, like all the trash. And, we just buffed the floors last weekend.
Were you doing the windows?
Yeah, I was doing the windows.
Which, honestly, I don't know if that was on the list of things that you must do, but I was completely shocked.
Yeah.
But anyway, and you've done this at other facilities too, right?
Yes, I did this, yeah.
That's all I got, Judge.
Thank you. Evidence from the state?
No evidence, Your Honor, just argument.
Okay. Mr. Nopes, argument?
Judge, I just think that from, what's interesting is a lot of times we don't know the story until we ask for the mental health evaluation. It's an amazing story that you think to yourself, what a journey, right? And there's so many things that could have happened to any of us, and we might have not have ever recovered. But she seems to me that she is willing to do the things that are required of her to get herself balanced and to move forward. And I just hope the court would consider that we've showed you that there is a reason that you can, if you want to, mitigate. And if you decide to, I'd ask that you follow Dr. Harper's recommendations And if you don't, I totally understand, Judge. It's your choice. That's why, you've got the road and you're the judge. But we'd ask you to consider a downward departure.
Thank you, sir. To the state.
Judge, we're seeking to impose the 36-month suspended sentence. She's before the court on her second VOP, and she did violate her probation. There were 8 allegations there. They included 2 new felony petty thefts, associating with someone engaged in criminal activity, failure to remain confined to residence, leaving the county of residence without permission, failure to remain confined to residence in her road to recovery, failure to report to probation officer as directed, and failure to follow instructions that would be report if released. In the underlying child neglect case from this VOP, she was clearly under the influence to the point of answering a door partially undressed, almost falling over with the child in her arms, falling asleep during the investigation, being unaware that the child was covered in feces, trying to feed him a curdled bottle. I bring this up to point out that obviously the neglect case was related to substance abuse. Her original plea included a 36-month suspended sentence. She did score over 20 months DOC and was given a downward departure at the outset by the state and was placed on probation with Keaton as a bars to bed program in 2021. We also took no action on an FTA. She then received her first violation of probation for failing to complete Keaton and was unsuccessfully terminated from their program in February of 2022. The allegations there were positive breathalyzer test, telling staff to suck her dick, possession of contraband, sleeping during meditation, violation of a cell phone policy, arguing with the director. During that first VOP, her supervision was modified and reinstated to conclude another substance abuse program in October of 2022. So again, she scored prison and was given another downward departure, another break by the state. On October 24th, 2022, just a few weeks after she was given that second chance, she was arrested for this VOP. And again, there was an allegation of felony petty theft on October 16th, and that was during hours which she was supposed to be on her CC schedule working. And she was also acting in concert with someone else, so that was associated with people that are associated with criminal activity. It also lists that she left her county of residence without permission. January 27th of 2023, she was still living at the road to recovery, and she asked probation officer if she could work. And they said that would be fine, but she would have to fill out a CC schedule if she left the facility and tell probation that very same day that's what she was doing. She indicated she understood that, but March 2nd of 2023, she told her probation officer she expected to be finished with road to recovery by March 27th. She was then charged with a felony petty theft case in Santa Rosa County 7 days later on March 9th. So she left the county of residence without permission, failed to remain approved to confine residence, which was the road to recovery, or tell probation she was living in the road recovery facility. She did plead to that case in front of Judge Duncan in June of 2023. As court is well aware, there's a 2-step basis of downward departures. First, whether the court can depart, whether there's been legally sufficient evidence to provide a valid departure reason, and secondly, whether the court should depart, and that's solely within the court's discretion. As Mr. Nope stated today, the primary basis for downward departure they're asking for is specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, and that the defendant is amenable to treatment. To qualify for a downward departure on this basis, defense must show and the court must find 3 things: the existence of the mental health disorder or disability, the need for specialized treatment unrelated to substance abuse, and that the defendant is amenable to that treatment. Dr. Harper said today that the defendant has major depressive disorder and panic disorder and ADHD by history. We would note that there weren't any previous mental health records that were consulted by Dr. Harper, and she conducted 2 tests. However, and this is the main point, it must be unrelated to substance abuse. If you read Dr. Harper's report, literally right after claiming depressive disorder and panic disorder are the issues for Ms. Baez, it says that she attempts to cope with extreme distress by substance use. And the whole reason she had this case to get a VOP in the first place is for substance use. Dr. Harper's recommendation include co-occurring disorder treatments supportive of not using drugs and alcohol. This was absolutely related to substance abuse or addiction, which would disqualify her for a downward departure on this basis. Defense also must show that there's a need for specialized treatment and Dr. Harper claimed the victim's counseling, the cognitive behavioral treatment, continue with any psychiatric care and medications she's already continuing with, and the substance abuse evaluation and treatment. And the court asked Dr. Harper, how is that specialized? And Dr. Harper's response was, well, it's not in group therapy. The state would submit that those treatments are not sufficiently specialized for a downward departure basis. Those are widespread. And we don't believe defense has met their burden under the first two prongs, but the last thing defense must show is that the defendant was amenable to specialized treatment. As far as being amenable to treatment, we would again remind the court of Ms. Bias's history in this case. Her first VOP was for being kicked out of Keaton program. She previously reported undergoing substance abuse and mental health services from 2018 to 2020 to Dr. Harper, and that was unsuccessful as she was charged with this neglect case for using substances in 2021. It also was noted in Dr. Harper's evaluation that she used drugs to numb her emotions and was committed to a hospital in 2023. Amenable to treatment means a reasonable probability that such treatment will be successful, and I don't think defendant's own history indicates she can do that. She's been given multiple opportunities for treatment that have not been successful. Dr. Harper also noted that when she's in the community, she had poor coping skills and was derailed by poor impulse control when she becomes emotional. So there's been a number of times where she sought treatment and it hasn't been successful, and that coupled with Dr. Harper's notes about her coping skills and poor impulse control when she becomes emotional give us concern about her amenability to treatment. So we don't believe defense has met their burden to qualify for downward departure on that basis. We would also note that under Florida Statute 921.0023, the fact that the defendant needs drug treatment or has substance abuse issues or addiction issues does not justify a downward departure under any circumstances except for 2M, which is the post-adjudicatory drug treatment program, which is when she's already in drug court, which is not the case here. I think it's great that she's been volunteering in the jail, as Major McDaniels testified to, but that also is not a downward departure basis. So we don't believe defense has met their burden. However, if the court does believe that she qualifies for a downward departure on that basis, and the court can legally depart, the second analysis will be whether it should. And we don't believe the court should in this case. Frankly, she's been given a number of chances to succeed by the state. The purpose of criminal courts isn't to rehabilitate the defendant, it's to hold her accountable for her actions. She was already on restrictive supervision when she committed this second VOP, and she's shown that she cannot comply with court orders or community-based supervision based on this VOP and her first VOP. She violated her probation in numerous ways, including failing to remain confined to her residence and receiving new law charges. And it's absolutely tied to substance abuse issues, which would make her ineligible for downward departure under Florida Statute 921.0026 subsection 3. So we'd ask the court to impose the 36-month suspended sentence and revoke and terminate probation.
Thank you, ma'am. Ms. Bias, a lot of different thoughts I have. When I was doing my homework and I read through the state's letter, you know, I saw all the different opportunities that you've had. Saw Keaton, Road to Recovery, I mean, all the different things, and you think, just in the silence of my chambers when I'm doing homework, just on the state's letter, you go, she's had enough opportunities. Then I read the doctor's psychological evaluation, certainly fleshes it out a lot more, the facts that come through from that. I've got to follow the law. I can't ask you to follow the law if I won't. So when I look at the requirement for downward departure, the defendant requires specialized treatment. I understand the state's argument on that. I understand what the doctor testified. I do find that you require specialized treatment for a mental disorder. State really argues that it's unrelated to substance abuse. In the report, and then the doctor on the stand said it's kind of the chicken and the egg. it's not that the offenses, the crimes were committed because drugs or alcohol was involved in that. It is, did the mental disorder, is it unrelated to the substance abuse? And the doctor testified that the mental disorder's first, and you try to cope with that by self-medicating, by using substances. And so I find that it is unrelated to substance abuse or addiction, your mental health. Are you amenable to treatment? The doctor's report and her testimony here today says that you are, and I believe you are. I believe that you're amenable to that you're ready for the change. The doctor used turning point. I certainly hope that you've reached that point and that you're tired of coming before the court. The state raises, and one of the Florida Supreme Court justices early this calendar year spoke to different folks, attorneys and judges, and when I spoke to him, he said, you have something that we don't. We have discretion, and that's what that should the court downwardly depart. And it's pure discretion on the court. And the court finds that I should downwardly depart. So when there was testifying from the doctor, I wrote down my own statement, and then later you testified what I hope for is, and that was in relation to your son. And that was the note that I made when the doctor was testifying. Nothing but hope. You also made a statement that you said, talk to us inmates. I hope that that drops out of your vocabulary and there's no more us inmates. Ms. Bias, you've always come in with your head up. You've come in with as much of a smile as you can manage. So I do find that you fulfill the statute. Your prior supervision is revoked and terminated. You're adjudicated guilty. You're sentenced to 3 years probation. You will need to submit to a psychological evaluation within 30 days from today, begin any treatment within 60 days from today. You'll need to submit to a substance abuse evaluation within 30 days and follow any treatment that's recommended by that. You'll need to pay the $40 per month, but I'll waive that for the first 6 months. $100 cost of prosecution, $150 public defender's fee. What have I missed from Ms. Bias?
And Judge, just to clarify, you're revoking her current supervision and sentencing her to a new term of 3 years of probation?
Correct.
Okay.
Mr. Nopes, and I was wondering about that too. As far as all of the prior monetary amounts, give Ms. Bias a year?
Judge, I think.
Or do you want her to pay that during her new supervision?
Judge, if we could do it over the supervision, that would be a much more affordable process.
So all of the financials are imposed as part of the supervision. Okay. Ms. Bias, you have to make it this time.
Yeah.
Not just for your son, for society, for yourself. You got to make it. Okay. Thank you, ma'am. I wish you the best.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Mr. Nopes. Thank you again,
That's all
Doctor.
I've got. Thank you.
And Judge, I believe that concludes my business. If I could also be excused.
Yes, ma'am. Thank you.
Thank you.
And thank you, Major, on Zoom. Okay. And what's next? Yes, sir.
Good afternoon, Judge. I'm here on behalf of Aaron Wallace. My name is Andy Demetrius.
Yes, sir.
And I just, I know it's 3:30 now, and this may take 2 hours, so I don't know. We came in from Fort Lauderdale, so I'm gonna try and finish this, and maybe I'll be here tomorrow through noon, so maybe if your calendar permits, or maybe we can finish closings through paper submission, but that's just to to give you a heads up and see if we can finish this.
Okay, before we do that, Mr. Dyer, what are you here on?
I am a witness in this
Good,
case, Judge.
okay. So everybody else is on this case. Mr. Koch, do you have anything that,
Sharman is still remaining from the morning docket, Judge.
okay, are you ready for that, Mr. Koch?
Judge, I am, and I spoke with the state already, so these will be brief.
Okay, please.
Mr. Wallace, do you need to step back in?
He's fine. Oh, you don't want two people? You got it.
Same thing. And then,
Yes, sir.
Judge, this is Ms. Jennifer Sharman in 23 CF 1665. It's in regards to a motion to compel. And I just want to make it clear, this is not a situation where the state has the evidence and they're not giving it to us. It's just clearly an FDL report. Speaking with the state, they put a rush order on that, and I'm asking just to impose a 30-day deadline to get that report from the state.
So order the state to produce that within 30 days.
Yes, Judge.
That's fine. Yes, sir.
Okay? Sharman, I do order that that FDLE report needs to be provided to your attorney no later than 30 days from today.
Yes, sir.
Okay? And am I seeing her on May 13th? Do I need to see her on May 13th?
We're scheduled for pre-trial on that date, Judge.
Okay, I'll see you then.
Okay, thank you.
ma'am.
Yes.
Okay.
And, yep, good. And Judge, I have another case on the same matter, if we can call.
Thank you, Ms. Sharman.
Thanks, Ms. Sharman. It's Mitchell Smedley, and
Yes,
I've
sir.
waived his appearance, and it's in 23 CF 632. And same circumstances, an FDL report. I'm requesting just the 30-day deadline.
To the state.
We put a rush on both of those cases at the same time, so that's fine.
So it's ordered that it needs to be produced no later than 30 days from today.
Thank you, Your Honor. That's all I had, if I may
Thanks,
be
Mr. Scott.
excused.
Yes, sir. Have a good weekend.
Thank you, too. Thank you.
Thank you. Okay. So on Mr. Wingless's. Do you want to start with the motion to strike? Or do you want to start with the motion for post-conviction relief?
The post-conviction relief, Judge.
Okay,
So I'd like to make a brief opening. At this time, I'd invoke the rule, Judge.
okay. So anybody that's in the gallery that may testify in Mr. Wingless's case, you need to step outside, not discuss the case with each other or with anyone else, electronically or face-to-face. You can discuss the case one witness at a time with either of the attorneys. So if you'll please step out until you're called to testify. Yes, sir.
Thank you, Judge. Hanny Demetrius on behalf of Mr. Wallace. This is a two-round 3850 motion, Judge. This case arose out of a 5-count, which ended up in an amended information. It was originally a 4-count information that ultimately went to trial on a 5-count information, 4 counts of ag assault with a firearm.
If you don't mind, if you'll turn that mic towards you, it'll give a better record.
Sure.
Thank you.
And 1 count of a regular ag assault. The issue at trial before the jury is whether or not Mr. Wallace was insane at the time of the incident. The jury came back and convicted on all counts, Judge. Ground 1 of the motion posits that there was a 5-year prison sentence that was a plea offer followed by 9 years probation. At that time, there were several issues that were not explained to Mr. Wanless. Had they been explained by his counsel, he would have accepted them at the time, and then there was an expiration to that plea offer, Judge, and the argument rests on essentially there was a lack of disclosure by the state, so his attorney at the time didn't have the requisite information to convey, so he could not make an informed, intelligent decision on that plea offer. The second ground, Judge, is when it came down to sentencing in 2015, the 10-20 life statute applied to ag assault. And then the following year, in 2016, ag assault dropped off that and is no longer part of 10-20 life. But at the 2015 statute, there was the last paragraph, paragraph 6, carved out an exception where the court, if they made a factual finding based on one of the enumerated grounds, the court could then not give the minimum mandatory 20 years. The second ground is his attorney at the time failed to make that argument. Had he made that argument, the court would have entertained that exception, and the result most likely would have been different. And that's all I have for an opening, Judge.
Yes, sir.
Well, as to count one, the issue basically boils down to whether or not he was informed of what he was facing, what his maximum sentence was, was he informed of any of his plea offers, what was his advice of counsel, was he given all of that before he made his decision, and the state will provide evidence that he was. As to count two, the provision that the defense is saying is a downward departure based on whether or not there was evidence of justification. There was nothing in this case that ever indicated that this was a case that he felt like, or that this was a stand your ground or a justification used to have any kind of assault or a battery involved. That didn't even apply to the case. So it would have never been raised by defense counsel to begin with. So that it didn't apply here. That's the state's position. So.
Okay, thank you. Yes, sir, you want to call your first witness?
Yes. We would call trial counsel, Judge, Mr. Diadrum.
Dyram is how, it took me a while. If you look at the spelling of it, it'll mess you up every time. Mr. Dyram.
Dyram.
Yes, sir.
Good afternoon, Mr. Diaram.
Yes, sir.
Am I saying it right? All right. How are you doing?
I'm doing well.
Can you give us a little brief introduction when you got admitted to the bar, what you practice?
So I was admitted to the bar in 2013, began working at the public defender's office, I believe in August of 2013, started in misdemeanors, then went to felonies. I left the public defender's office in 2017, February, I believe, and I've been in private practice since then.
Okay. And you were admitted at the end of 13?
Yes, sir.
And then this case originated in 2015?
Yes, sir.
All right. Do you recall the sentencing in this matter?
I do.
And did you in fact move to have the court, let me rephrase, did you make an argument that 10-20 life didn't apply in this case?
I believe I did.
And what was that argument?
That I believe the laws had recently changed, that the aggravated assault on law enforcement was removed from the 1020 life statute in 2016. And although Mr. Wanless's incident occurred in 2015, we argued that the court should not sentence him according to the 1020 life statute.
So it was your intent to not have the 20-year min-man apply to his case? And what happened when that was argued at sentencing?
After he was convicted, I believe we did have an argument in front of the court, and then Judge Stone asked for briefs to be provided, so I believe we broke, and he gave us a deadline of maybe the next day. So I believe those briefs were filed, and then we came back, and then the sentence was imposed.
So the judge wanted some guidance as to whether 1020 life applied or not.
I believe so, yes.
And the sentencing was stopped in order for the judge to have some guidance on that point?
Yes.
And at that time, the state wanted to kind of proceed and kind of finish it that day. Do you recall that? Do you recall the judge wanting time for you to have adequate time to present that issue to the court?
Yes.
All right. Are you familiar in the 2015 statute 775.087, paragraph 6?
After reading the motion that was filed by your office, I believe I am now.
Okay, at the time, were you familiar with paragraph 6?
I do not recall.
Okay. Can you tell us what paragraph 6 calls for?
I believe it calls for the court's discretion to depart downward.
Okay. Or would it be more fair to say the court can impose a minimum mandatory if they make a finding to one of the enumerated reasons?
Yes.
Okay. And is one of those reasons the aggravated assault was not committed in the course of committing another criminal offense?
I believe so.
Judge, if I could just take a minute now, and I'd ask for the whole record to take judicial notice of.
Any objection, Mr. Snow?
Say again.
To have the whole record to take judicial notice of the entire record.
Of the court file?
Yeah. Mm-hmm.
Yes, sir. That's granted.
Thank you. All right. Let me ask that question again. Subsection B of paragraph 6 says the aggravated assault was not committed in the course of committing another criminal offense. Are you familiar with that subsection?
Yes.
All right. And there are 4 subsections altogether?
Yes.
One of them is also D, the totality of the circumstances involved in the offense do not justify the imposition of such sentence. Is that correct?
Yes.
And why didn't you argue that Mr. Wanless has a carved out exception that the court could have considered in not imposing a minimum mandatory?
I did not think that it applied at that time.
Why does it not apply?
Based on my review of the facts and in preparing for sentencing, I did not think that there was a valid argument to be made
For
those sections.
so you believed he didn't qualify for any of the 4 subsections? Okay. So you don't feel that you could have argued B, the ag assault was not committed in the course of committing another criminal offense? Why not?
Because if I'm not mistaken, prior to law enforcement showing up at David Wallace's house, Aaron Wallace had threatened his father with a knife and also threatened to kill a cat. And I believe that was pretty close in time to when the aggravated assaults happened.
So that happens, correct? And then there's a period where his father leaves the residence, calls the police, and then the police come, and then the second part happens. Is that correct? Okay. C, the defendant does not pose a threat to public safety. Did you think you could have argued that?
I don't believe so, no.
Why not?
Because he was just convicted at trial of aggravated assault on law enforcement with a firearm. And frankly, that would have been up to the court at that time.
Okay. So you don't think you could have made an argument based on that, even though he had substantiated mental health issues? D, the totality of the circumstances involved in the offense do not justify the imposition of such sentence. Did you think you could have argued that?
Well, I think I did essentially argue that. I don't think that he should have received the lengthy sentence that he got. But ultimately, it was the court that sentenced to that, so I didn't have any control over what he got.
Right. But what you were saying, correct, is that you didn't feel that the minimum mandatory was justified in this circumstance. Is that correct?
Right, because aggravated assault has been removed from that statute.
Okay. So if it's your belief that that's your argument, then you could have argued 6D to the court as a finding it could have made, and they could have, and the court could have, had it made that finding and agreed with you, would have been prohibited from imposing the minimum mandatory sentence.
That would have been with Judge Stone. I don't know the answer to that.
Okay. But what I'm saying now is that essentially, if you're saying you were trying to argue that, here was 6D, you could have argued and presented it to the court. Is that correct?
I suppose.
Okay. So would it be fair to say that there was no strategic reason for you not to do so?
Well, at that time, I did not think that those applied. I didn't think that there was a valid basis for me to argue that.
Okay. But you just testified that you believe that you, in fact, did argue that same idea, but not under 6D.
Right, not that subsection.
Right. But you argued that idea, not in this subsection.
That I believed he should not have been sentenced pursuant to 10, 20 life, yes.
Right. So my confusion is, why do you think that you can argue that idea outside of this subsection and then now say, well, I don't believe I can make that argument under the same concept under 6D?
Well, the law had recently changed, so we were arguing that because the aggravated assault was recently removed, that it should not apply to him. That was the basis.
Okay. And you were also saying, if I'm correct, that you didn't believe the 20-year sentence was justified.
He got 48 at the time.
Right.
Sentencing, I didn't think that was justified, but I'm not the judge.
Okay. And if I recall from the beginning of your testimony, you weren't sure whether you were familiar with 6D or paragraph 6 at the time of sentencing.
several statutes during this time, so I can't tell you if I specifically read 16. I'm sure I did. I don't recall. I don't recall discussing it with Aaron. We may have.
All right. And then it was at sentencing, this was the first time you had raised to the court the argument that the minimum mandatory didn't apply, correct?
Yeah, I don't know if there would have been an appropriate time prior to sentencing.
I'm just asking if you recall whether that was the first time or not it had been raised. Okay. Judge, I'm gonna show trial counsel a copy of the sentencing of the first date of sentencing, page 86. I'm gonna pull up the date of that sentencing. What is it? January 17th of 16. If I showed you a copy of the transcript, would that refresh your recollection on whether it was the first time the court was made aware of the minimum mandatory argument or not?
Yes, sir.
May I approach, Judge?
Yes, sir.
What I'm going to direct you is page 86 from 14 onto the bottom, the last line 25, I believe is when it addresses the issue. Did that refresh your recollection as to whether that was the first time the court was made aware of the minimum mandatory argument that you raised?
Yes.
Okay, and was it the first time?
According to the record, Judge Stone, yes, it was.
Okay, and you made the argument essentially that it's the date of conviction, not the date of incident, that triggers the statute, and therefore the min-man shouldn't apply, because at the time he was convicted in 16, the legislator had modified the statute. Is that correct?
If that's on the record, then yes.
All right. And then ultimately the court wanted direction as to whether there was any case law on that matter, because the state was making the contrary argument to you. Is that correct?
Yes.
And that's when briefs were submitted on that issue, and then the judge came back at a later day and pronounced sentence. Is that correct? All right. Now, in this case, the defense was insanity. Is that correct?
Yes.
And there came a time where you believe the state withheld information from you. And as a product of that, you filed a Richardson hearing.
Yes.
All right. Just so we have some dates in place for the court, do you recall the date that the plea offer of 5 years followed by 9 years probation was communicated to you? All right. If you saw a transcript, would that refresh your recollection?
Yes.
I'm going to show him, Judge, the transcript from June 17, 2016. This is from, no, in court, the docket date. May I approach, Judge?
Yes, sir.
Show you page 3 if you want to read from the top. There's a highlighted section starting on line 6. So based on that, do you know when the plea offer was relayed to you by the state?
If that was June 16th, is that right?
June 17th.
June 17th, 2016. I don't know what day of the week that was, but I'm assuming I had a discussion with now Judge Schlechter probably a couple days prior. So during my talks with him, he must have informed me of that.
Okay. And the transcript says, and you're saying this on page 3, line 6, and the state has also given amended offer yesterday, which I've relayed to Mr. Wanless.
June 15th then.
June 16th, if this is the 17th.
Sorry, but the day that I received the offer from the state would have been the day prior, right? Is that what I put on the record?
Yeah, so if this is the 17th and your testimony was you got the offer yesterday.
Correct, sorry, yeah, June 16th.
Okay. And at this time, you're also bringing up the Richardson hearing during this docket day. Do you recall that?
Is that related to Deputy Ross?
It's related to photos, Facebook messages, police reports by multiple
I
officers.
thought that I had filed maybe 2 Richardson hearings, so I can't.
Yes.
That one was just before trial.
This is the one I'm referring to that you filed on June 21st, 2016.
Yeah, I do not specifically recall that one.
Okay. And the 2 things that were addressed other than on June 17, 2016, other than you informing the court that you just gotten that offer, was also, other than the Richardson hearing, is also that you were moving to, you moved to strike Mr. Bingham?
Dr. Bingham?
Dr. Bingham.
That sounds right.
Okay. And you proceeded to a Richardson hearing on June 23rd, 2016? Okay. And you also, in between the 2 dates, the 17th and the 23rd, so the 17th of June was on a Friday. You also had said you had 10 depositions on this coming Monday and Wednesday of the next week. Do you recall that?
If it's on the record, then I said
Okay. So those were 20 depositions to be done in those 2 days. And then the Richardson hearing was held that Thursday on the 23rd of 2016. Do you recall that?
I don't specifically recall the hearing, but it was on that day.
All right. Do you know why all those depositions were done in those 2 days at that stage in the case?
I do not recall. I know I think I inherited the case in 2015. There was another attorney from my office that initially had the case, and then she took some leave, and I took over, but I can't specifically tell you why those depositions were done or who those witnesses were.
All right, if I showed you a transcript regarding that issue, would that refresh your recollection?
Yes.
And again, this is from June 17, 2016, page 5. May I approach, Judge?
Yes, sir.
Page 5, and if you want to start from line 6. Do you recall how those depots were set in those 2 days?
Based off of the record, it seems like I did not have knowledge of certain witnesses, so once evidence was turned over from the state, I set depots.
Okay, so because of the Richardson issue. All right. And in between that time that you were in court on 17th with Mr. Wanless, and then you came back on the 23rd of June, 2016, less than a week later, is that the time where the offer was to expire?
I do not recall when the state said they were going to revoke the offer.
If you saw the record from June 17, 2016, would that refresh your recollection?
Yes, sir. Yes, sir.
I'll show you page 10, starting from line 2. Does that refresh your recollection as to when the offer was going to expire?
Well, Mr. Schlechter kind of left it open-ended. He said it will be open until docket day, but it may not be open past that.
Okay. And June 23rd, 16 was the docket day?
I guess so, yes.
Okay. Now, you did these depositions because you believed that there was going to be some value in doing them. Would that be fair to say?
Yes, sir.
So those 20 witnesses had potentially valuable information. Is that correct? All right. And then on June 23rd, 2016 is the docket day that Mr. Wanless rejected the plea on the record. Okay. I don't have anything further, Judge. Thank you.
To the state? Yes, sir.
You testified earlier that you read many statutes leading up to the trial regarding sentencing or leading up to the sentence. So if you read a statute, you said you weren't sure whether or not you read, was it 775-0876? You say you probably read that?
Yeah, probably did. I just don't recall specifically when or if I discussed it with.
Okay, so when the statute says that the court would have to make written findings that the defendant had a good faith belief that the aggravated assault was justifiable pursuant to 776, and aggravated assault was not committed in the course of committing another criminal offense, the defendant does not pose a threat to the public safety, and the totality of the circumstances involved in the offense does not justify imposition of such sentence. Do you think that the court can make written findings of all four of those enumerated things?
Judge, I'm just going to make an objection as far as that statute does not include the word "and" after between the third and fourth subsection.
Thank you.
Okay. Based on if you read that statute, you wouldn't try to bring a defense or move the court for a downward departure based on something that you didn't feel was in play or could be proved or persuaded, I guess, if you will, to the court.
Yeah, I believe that there was merit, and I would not argue that.
Now, as far as did you feel that the defendant had a good faith belief that his aggravated assault was justifiable? And you testified that you felt like the aggravated assault was committed during the course of committing a different criminal offense?
Yes.
You testified earlier that there were substantiated mental health issues involved in this event? When those substantiated mental health issues and the tenseness of that situation and the mental state of the defendant, that's possible that he would pose a threat to the community, correct?
Yes.
Now, when it comes to D, the totality of the circumstances, you did move the court. You asked the court for a downward departure, correct?
I did.
What did the court do?
They did not find the argument valid.
They did the opposite, correct? He added consecutive sentences, right? So there was no inclination from the court that they were looking to find a reason to downward depart, correct? No further questions. Thank you.
redirect.
Do you recall the court's findings or the order on the Richardson hearing that we previously discussed? Okay. So the judge, for the record, Judge, on October the 10th, 2016, there's an order on defendant's motion for the Richardson hearing. Do you recall if the court found the violation to be substantial?
I do not recall.
Do you believe if the court found the violation to be willful? Did the court find that the defendant suffered prejudice as a result? If I gave you a copy of the order, would that refresh your recollection? I'm going to count out the pages, Judge, so for the record's clear, because it's not paginated, the order. Beginning on page 5, where it has the analysis.
Yes, sir.
And again, this is the October the 10th, 2016 order on the Richardson hearing.
Would you like me to read the whole?
That's the beginning of the analysis I showed you. I've underlined some portions that may help you out. So, in here, did the judge find it to be willful, the violation?
Your Honor, I'm going to object to relevance and the scope. This is outside of the scope of why we're here. So far, he's talking about Richardson violations. There hasn't been one single thing about what he omitted. What act or omission did he do? It sounds so far, all we've talked about is that he acted well on behalf of his client. We're talking about Richardson violations. This has nothing to do with whether he adequately advised his client of the situation. of what the case was, what the sentence, possible sentence would be, any of that. So far, we're not anywhere near that. So
Why is it relevant?
Judge, I set up the framework time-wise, June 16th of 2016. The offer is relayed. They have court on the 17th. The offer expires on June 23rd, 2016. The point of going over this is to demonstrate, to lay the record, to show the court that the state committed a Richardson hearing, thereby not giving proper information to trial counsel. Therefore, trial counsel was unable to relay pertinent information to Mr. Wanless in order for him to make an accurate, informed decision on whether or not to accept a plea offer. And according to Florida Supreme Court Alcorn, what matters is the information that Mr. Wanless had at the time of the plea offer. So that's why I'm going into the information known to trial counsel at the time the plea offer was submitted.
that's not ineffective assistance of counsel. He's not saying that Mr. Darren didn't provide the information. He provided all the information that he had at the time that he was provided in a timely manner. So this is not a 3850 issue if that's the case. That's something he should have appealed, or the defendant could have filed an appeal on that. But
I understand your argument, but the objection's overruled. Yes, sir.
Thank you, Judge. Did the court find that the Richardson hearing was willful?
I don't believe so.
Okay. I'm going to show you again the order. Actually, I'm just going to read from it, Judge. It's in the record. Although the court, and this is from page 6, first paragraph, actually the last sentence. Although the court finds no malicious intent on the part of law enforcement or the prosecutor regarding the discovery violations, the violations were technically willful because they stemmed from the failure of law enforcement in the state to establish an adequate communication system regarding discovery materials. Mr. Diaram, did the court find that they were substantial, the violations? All right, I'm going to read the following sentence in the order. The discovery violations were substantial due to the cumulative effect of the quantity of the materials that were ultimately disclosed. And then I'm going to read up a couple lines. Had the discovery violations in this case been brought to the court's attention during the trial rather than prior to trial, the remedy for the violations would likely have been exclusion of evidence and the possibility of granting a mistrial. Did Mr. Wanless suffer prejudice, did the court find? All right, I'm going to read from the last paragraph on the same page. However, both defendant and the state indicate the discovery violations were relevant.
I'm going to object again. May we approach?
You don't want the witness to hear? Why do you need to approach?
This is not even contained in the motion, so it's not even in the scope of why we're here.
Okay. Yes, sir. How was the state on notice that you were going to argue this?
Judge, we laid in a very clear fashion all the issues that were not communicated to Mr. Wanless. Now I'm showing the record of why it wasn't shown to Mr. Wanless.
Okay. Why don't we take a 10-minute recess and then we'll come back? Okay.
All right.
Like if you don't mind.
All rise, please.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a...
Welcome back, Mr. Wiles. The objection, I understand, the the state's objection, respectfully, it's overruled. Yes, sir.
Judge, and I just want to lay one more thing. It was to the question of whether he suffered prejudice, and then we can move on to the next witness, is that the final sentence in the analysis, it says, therefore, the defendant suffered prejudice due to the discovery violations.
Thank you.
And that's all I have, Judge.
Okay. You have any other questions?
No.
Okay. To the state, questions for Mr. Dyer?
When you receive discovery from the state, did you make an analysis of it and immediately share it with your client?
Yes, as soon as I could.
To your knowledge, is there anything about the case that you didn't share with your client? Thank you. No further questions.
Since I had to recross.
No,
is there
Judge.
Anything else?
Nothing further.
May Mr. Dyer be released?
No, sir.
You want him to remain?
Yes, sir.
Okay. Thank you, sir. If you'll step out. Your next witness.
We call Aaron Wanless, Judge.
Okay. Mr. Wallace, if you'll please come to the stand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, Your Honor. Thank you, sir. Please be seated. Yes, sir. Questions?
All right. Mr. Wanless, how are you today?
I'm good, thank you for asking.
Do you recall being made a 5-year plea offer in this case?
Yes, sir.
Okay. And do you recall how much time you had to think about that plea offer?
I believe it was about 5 to 7 days, within a week.
And at that time, did you have all the discovery in your case?
No, sir. Prior to this, I had asked Mr. Dayaram for the discovery, and I was just given some police reports.
Okay. Subsequently, were you ever given more discovery?
No, sir.
All right, let's start going through some of the points that are in the motion. Did Mr. Dayaram explain to you that voluntary intoxication would negate an insanity defense?
No, sir.
Okay. And what I'm specifically referring to was your dad's testimony on body-worn cam saying that you were drunk. Do you recall that evidence?
The only time I ever saw that evidence was April or May when I had my bond hearing, and it came on, and chaos took over, and I just started weeping and crying, and so I don't really recall the video itself.
Okay. Did your attorney explain to you that if you have a witness saying that you're drunk at the time, that would ultimately completely contradict and take away your insanity defense?
No, sir, because then I wouldn't know why you would want to put in insanity defense.
Okay. Now, you had an expert, or your attorney had an expert evaluate you for insanity at the time of the offense. Is that correct?
Yes, sir.
Did the state have an expert?
Yes, sir.
At the time of the plea offer, had you seen the state expert, Dr. Bingham's report?
No, sir.
Had your attorney told you about what Dr. Bingham's findings were before you rejected the plea offer?
No, sir.
At the time that the plea offer was pending, do you recall how many charges you had?
4.
Okay. And shortly thereafter the plea offer, did the state amend the information?
This is correct.
To how many charges?
They added an additional charge of aggravated assault upon my dad.
Okay. Was that with or without a firearm?
With firearm with discharge. Yes, sir.
When you were deciding whether or not to accept or reject the plea, did your attorney advise you that if you reject this plea, the state could amend the information to additional charges?
No, sir. I was actually shocked when I didn't even know they could do that. So
All right. So factually, as the police were arriving is when you came out of the house and discharged a firearm. Is that correct?
yes, sir.
Did your trial attorney explain to you whether or not you fired the gun at or not at the police, you could still be convicted of ag assault firearm on law enforcement?
No, sir. At the time, I was under the understanding that they had to be shot at, and that's what I was being accused of, was that I was shooting at the police.
Okay. Now, did your trial attorney inform you that the in fear part of the ag assault charge is an objective definition? Do you understand what that means?
No, sir.
Objective meaning, would a reasonable person be in fear, as opposed to was that one victim in fear or not? Do you see the distinction?
Yes, sir.
Okay. Did your attorney make that distinction for you?
No, sir. And actually, it come up and said, well, Deputy so-and-so said he wasn't in fear, and your dad said he wasn't in fear, so that's going to help us. So it kind of propagated the hope, I guess, I suppose, moving forward.
What did Mr. Dairon tell you about 1020 life as it applied to your case?
I don't, other than the mandatories, that was it. I mean, it was just, it's an enhancement, and it's a min-man, is what you called it, a min-man, and I'd be subject to, no game time, it's day for day.
And when he explained that to you, did he say that's definitive or it's a possibility?
I believe at the time that it was definitive. And then upon the information about the legislation making the bill come through, I believe it was Senate Bill 216, and they passed that unanimously, and that would take effect July 1st. Then that's when, I guess, how do you say it? I forget the word, but anyways, that's when things started to come into question. Like, hey, look, this bill just went through, like, is this gonna apply,
Is this a hypothetical, or is this a conversation you had with your
it's
attorney?
an ongoing conversation from that time of information was received by both me and Ricky, that, throughout, all the way up through the sentencing, that it may not apply because it's an enhancement.
When you're saying it may not apply, is that what your trial attorney told you, or that's what you assumed?
No, that's what we discussed. It was more of a discussion. He said it may not apply, and I said, well, I don't think it applies either,
Okay. So out of everything that we've gone through, had you been properly informed on all those topics, would you have accepted the state's 5-year plea offer?
Yes, sir.
Why?
Most definitely. Because A, the mandatory sentencing guidelines were in place at the time. And had I known about certain case law that it doesn't matter, it's just what, at the time of the offense. And then the other thing is because of the whole substance drunkenness, you know, where basically I believe Dr. Bingham said that I was drunk at the time, and that eviscerates the whole insanity defense. So, and I didn't learn about that though until I heard Mr. Bingham testify to that in December during trial.
Okay. You didn't know that that was going to be his findings, or you didn't know that legally that would eviscerate your defense?
I suppose maybe both. I didn't know it was going, you know, I didn't know it was going to eviscerate the defense, and I didn't know that was in his findings until that day on trial where he gave his testimony.
And you heard the discussion about those 20 depositions that were taken in 2 days. Did you hear that?
Yes, sir, I did.
Okay. Was Dr. Bingham's deposition in one of those days?
I'm not aware.
All right. Nothing further, Judge.
Thank you. Mr. Snow?
I'm going to talk to him about this later. You said that you had ongoing conversations with your attorney about these matters that you guys were just discussing. That's correct? How many discussions, how many conversations do you think you guys had?
On which matters?
On the 1020 life.
On the 1020 life? Maybe half a dozen or so.
Okay. And during those conversations, you guys talked, you said that it may apply or it may not apply, right?
Right, yes, sir.
So you were aware that it's a possibility that it'll apply?
I was aware of the possibility, yes, sir.
Okay. I want to approach and I want to show you a letter. Okay?
Yes, sir.
Do you recognize that letter?
Yes, sir.
What is that letter?
This is the letter Ricky gave to me to inform me about the decision of the plea.
You mind reading that for me?
Yes, sir. It's dated 6/22/16, 15 CF 727, Mr. Wanless. I'm writing this letter to inform you that it is my advice to accept the offer from the state attorney in case number 15 CF 727, in which you are currently charged with 1 account of aggravated assault and 3 accounts of aggravated assault on a Leo with firearm with discharge pursuant to 1020 life statute. The aggravated assault on a Leo with firearm with discharge pursuant to 1020 life statute carries a minimum mandatory of 20 years per count for a maximum of 60 years DOC. The current offer is 5 years and 6 months DOC to run concurrently between all counts, with a 3-year minimum mandatory with all credit for time served. This is a plea to a lesser included offense of aggravated assault upon Leo with a firearm, no discharge. If you so choose to exercise your constitutional right to a jury trial, I shall be your advocate. I am prepared to defend your rights to the best of my ability. Sincerely, Ricky Dayaram, and sign him, Aaron B. Wanless, and sign my name.
That is your signature?
Yes, sir.
Is that an accurate copy of the letter that you went over with your attorney?
Yes, sir, that is correct.
So at that time, you understood that 10-20 life was a possibility?
Yes, sir. That's the.
And that came in, you contemplated that when you made your decision?
Yes, sir.
To go to trial?
Because at that time, it hadn't been argued whether it did apply or didn't apply.
Right. So you were hopeful that it didn't apply, but you were very aware that it very well might apply, correct?
Right, based on my counsel's advice. Yes, sir.
I'd like to admit this. Do you have an objection to that? I'd like to make this a state exhibit A.
Yes, sir. Any objection?
No, Judge.
It's admitted. Thank you.
No further questions at this time.
Okay. Redirect.
No, Judge.
Okay. Thank you, sir. You can step down.
Thank you, sir.
Yes, sir. Any other evidence from the defense?
No, Judge.
Any evidence from the state?
No, sir.
Okay. God bless you. So you'd mentioned argument. You want to do it orally?
Sure, Judge.
Okay, please.
Okay. All right. So I'm going to start off with ground two, Judge. So ground two essentially showed in the statute from 2015, paragraph 6, that allowed 4 separate instances, or bases, shall I say, where a judge could make written findings. Specifically, it says, paragraph 6, notwithstanding statute 27.366, the sentencing court shall not impose the mandatory minimum sentence required by subsection 2 or subsection 3 for a conviction for ag assault. So mind you, this whole statute of minimum mandatory, the only carved out exception to any of the enumerated offenses is ag assault. If the court makes written findings that A, the defendant had a good faith belief the ag assault was justifiable to chapter 776, which is the self-defense statute, right? That does not apply in this case. I concede that, all right? B, the ag assault was not committed in the course of committing another criminal offense. So here's where we believe defense could have argued the offense that happened with his father had ended, his father left, called the police, and then a new set of circumstances happened in a different location outside of the house at the time. So it wasn't in the course of committing because the first crime had already happened and it was done. It's not like a robbery and then a battery, right? One was done and it was final. C, the defendant does not pose a threat to public safety. Again, there's an argument there that Mr. Wanless, both sides conceded that he had mental health issues. The only issue was, did it rise to the level of insanity at the time of the offense? So again, he could have made an argument to the sentencing court, judge, mental health issues documented. It's but for his mental illness. Once he's properly cared for on the right medication, he is not a threat. And D, the totality of the circumstances involved in the offense do not justify the imposition of such a sentence. I think the initial 48-year sentence did not call for that. And I think by the state's own offering of 5 years, they believed something less than the minimum mandatory was a just sentence. And they put also on the record when they offered it, they consulted with all the victims in the case and they signed off on that 5-year sentence. And Mr. Dioram's testimony doesn't make sense, right? He says, well, I raised that, however, I raised it in a different format. Well, why didn't you raise it in the statute? Well, I raised it here. His initial response to this was, I don't know if I was aware of it. Well, I don't think none of this applies. I don't think his explanation made sense, Judge. Here's a trial attorney who is actively litigating whether the min-mans apply. Any trial attorney is going to use everything in their arsenal to make that argument and let the court decide. And it was clear on the record that the sentencing court was interested in this issue. The court just didn't gloss over, does the min-man apply or not? The court stopped trial counsel and said, this is the first time you are making this argument that it doesn't apply. The state's saying something in opposition. I'd like some information. I want guidance. So if the court was out to sentence him to 48 from the get-go, it would have just gone over, not given the time, not been interested, not, fleshed out the issue. And the state at the time says, well, Judge, give me 10 minutes, let me do the research. And he says, 10 minutes, that's not going to be the issue because you're going to look up something and then I want sufficient time for the defense to make a cogent argument, to have some basis, right? And I would posit, Judge, that trial counsel wasn't prepared on this issue because he makes it, right? And he brought no case law or support to back it up, which would always support my argument that I don't believe he was aware of paragraph 6. And what I would also say, Judge, that in this interpretation, there is no word and or in all four. So I don't think there's ambiguity. If it doesn't say and, that means it's not as one composite, it's each individual. So I don't think there's any ambiguity there, Judge. And, if that is the issue, we've cited in our motion and the reply, the rule of lenity applies, which is by statute. And the Weeks case from the Supreme Court, the Florida Supreme Court, which we cite, also essentially says in our reply to the state's response, essentially says when there's two competing interpretation, it goes to the defense favor. Because essentially the concept is we want a system of justice that the plain language people can understand. This isn't a gotcha system of justice. This is people should be come in and informed and understand. And that's why, and that's what they even say in the reasoning, Judge, is because they want people to be informed, So that's why it goes in favor. So even if you go with any of the arguments that's ambiguous and something else should apply, there's a statute that says how it should be done, and it's been interpreted by the Supreme Court, and it's got plenty of precedence, Judge. And again, the court was interested and willing to take a break, a significant break, to end the sentencing. And even the state was pushing and saying, but Judge, we have Mr. Wallace's family flew in, and he's like, you know what, I want this issue presented accurately so I can make a rendering. So if the court at that time, when they make that finding, they say, all right, I believe the min-man applies based on what I've seen, then if they're going to sentence him, they're going to sentence him in accordance with what they believe the legislator intended. Because once it becomes a min-man, that's an indication to the court that it's a serious offense, and not to use your discretion. It's to use what the legislator has deemed as an offense. And again, the most telling piece is, again, 2016, they do away with ag assault, So that's the real legislative intent. They first carve out a section, and then they go to the next step of excluding it altogether. And there's no strategic reason why trial counsel would have not made that argument. As far as the first ground, Judge, we've filed a motion So, Judge, the real issue behind the motion is Mr. Wanless having the ability to understand an insanity defense. He testified that he didn't understand that voluntary intoxication would negate his insanity defense. And in the body cam, his dad is there in a very hysterical, emotional state saying he's drunk, he's this, and he tells police he drank this much. And that was one of the issues of the Richardson hearing as well, Judge. It was a statement from David Wanless, the father, that was not disclosed. And you'll even find that substantiated in the trial judge's order on the Richardson hearing. The next issue is the report, Judge. Mr. Bingham's deposition. Dr. Bingham's the state's expert who is the one that negated the insanity defense for the state, happened on June 22nd, 2016, which is the day before Mr. Wanless rejects the plea in open court. So what happens is on the 16th, trial counsel's informed of it. He tells them on the same day the plea. The 17th is when they have that day in court where they bring up the motion to strike Dr. Bingham and a potential Richardson hearing. And then they say, and in the coming Monday and Wednesday, we've scheduled 10 witnesses per day, a total of 20. Dr. Bingham was on that Wednesday. So if you're doing 10 depositions in one day, there's no way his attorney has the adequate time to tell him, I did 20 depositions. These were my findings. Make an informed decision. It's just not possible, Judge. The appropriate thing to have done would say, Judge, you've seen that we've had 20 depositions. There's a Richardson issue. There's a motion to exclude a state's main witness. We'd ask the state to open up that plea offer for a longer period so I can discuss this. There's no reason that trial counsel kept his foot on the pedal. He in fact wanted to keep this on for a trial or a plea date, and it served no purpose because ultimately the court made a ruling on his June 23rd, 2016 Richardson hearings when they had testimony. The order came out all the way in October, so 4 months later. But on that 23rd day is when the plea offer closed. And again, the issue of amending the information, the amendment happened subsequent to the rejection of the plea. It is dated on the 29th day of June 2016 when they added an additional charge, and the plea was rejected 6 days before on the 23rd. Again, you heard Mr. Wanless's understanding of ag assault. He believed if he just shot in the air or away from police, that's a defense. When in fact what happened is the shooting happened and then police came and instructed him to put the firearm down. He didn't. He kept almost raising. They said, if you raise it, we're gonna shoot you. And he's telling them, shoot me, shoot me. He was in a mental crisis. He wanted to commit suicide by knowing if he raised that firearm, he was gonna get shot. And they were telling him not to raise it. He tells them, I'm on my meds. And he didn't understand the fact by raising it, or even not even raising it, the fact that you have a firearm, police are instructing you to put it down and you're not doing it, any reasonable person would be in fear. He was not told. He was under the impression, if I didn't shoot it at them, it's not an ag assault. And again, there's controversy about the 1020 life, Judge. Yes, it's documented in that letter. But however, you heard from his testimony, he had discussed with his attorney that the case law put it in play, and he was unsure of its enforcement. And you also heard his testimony that had he been told of all these relevant legal matters and understanding, he would have taken the plea. And I want to say, I'm going to refer back to the order, Judge, on the Richardson's hearing. Had these violations been brought to the court's attention during the trial rather than prior to the trial, the remedy for the violations would likely have been the exclusion of evidence and possibly the granting of a mistrial.
Does it say rather than prior to the trial?
Yes.
Okay.
So this happened prior to the trial. So what trial counsel asked for a remedy was, Judge, exclude the evidence, and the judge said, we're not in trial posture. I'm going to make the appropriate remedy of giving you more time.
Understand.
So I read that to show the court the extensiveness of the Richardson hearing. This isn't just one thing is missing. This is so many things that it would have caused a mistrial, possibly, and the exclusion of evidence, which are the which is the most extreme remedy a court can give. And I'd also say that the fact that he did 20 depositions is significant. Trial attorneys don't just take every deposition just because someone's listed. You make a decision to say, this person's relevant, I need to know what they're going to say. They have some information that I need to know. And that's what his trial attorney testified to. And I'd say, out of the specific things that Mr. Wanless testified to not knowing by trial counsel, there was no substantial competent evidence from Mr. Diadram that he specifically addressed those things and explained them to them. There was only the question of, did you explain matters, I want to say, I'm summing it up, did you explain matters that were relevant or before relevant to Mr. Wanless to him? And the answer was yes. It wasn't a specific explanation of each and detailed allegation that was made in the motion, Judge. And again, as far as the substantial violation, it also, just to refresh the court's recollection, the discovery violations were substantial due to the cumulative effect of the quantity of the materials that were untimely disclosed. And that they were the violations of discovery were relevant to insanity, right? Because during the pendency of this case, there was body-worn footage, body cam, so you could see what was happening. So there was no real controversy as to the act. It was the context and the mind state of Mr. Wanless, which can only be created through the evidence that happened prior to the incident and subsequent to the incident. And those were the things that were missing, that were produced in that discovery violation. Photos of medications, Facebook messages between him and his wife, other reports, his father's statement, all things that describe the mental state that both attorneys had to work with. And we've established again that time for the 17th to the 23rd. That information was still being processed in those 20 depositions. There's no way his trial attorney had the requisite time to do the work, convey it to him, and him to make a decision in rejecting it. And you saw evidence of that in Mr. Wanless's credible testimony. Thank you.
Thank you, sir. Mr. Snow. Yes.
So, I think that what we've heard here today has been nothing but positive when it comes to the performance and the representation that Ricky Durham provided to Mr. Wanless. He was diligent. He worked hard. As soon as he held the state's feet to the fire, as soon as he got evidence, he went and talked to his client about it. He communicated with the entire family. There was the defendant indicated that he had six discussions alone just on 1020 life, right? So, you know, there was a statement that Mr. Derham put his foot on the gas and wanted to go to trial. So I was not involved. I didn't work at the state attorney's office. I don't know anything about this case. However, I do know what happens when cases are set for trial and when they're 2 years old. Okay? What happens is sometimes there is no more room to continue a case and you guys have to go. I don't know for a fact. I don't know. I would guess that this is a situation where the state and the defense were going to trial because that's when they had to go. I don't feel like, I think that every lawyer wants to be completely 100% prepared before they go to trial. And it sounds like that Ricky did everything he could to make sure he was prepared. He took 22 depositions in whatever time you just said. And it's important to note that there's nothing that's been established that said the offer of the 5 years was revoked. That's never been established anywhere. The prosecutor did say, I'm probably going to revoke it at whatever, but he left it open-ended. At no time was that ever decided that he didn't have that offer. So the two-prong test in Strickland versus Washington is, that's a big burden, okay? The defense would have to show particular acts or omissions of trial counsel that were so outside the broad range of reasonably competent performance of the professional standards of that day. So when you say broad range of reasonable competence, so what that says to me is all legal representation isn't created equal, and there's a wide spectrum. Based on what we heard today, I would say that Mr. Derham's representation is at the top as far as effective assistance of counsel. That prong clearly to me was not met. Now, let's say if there was an error that Mr. Derham committed, it would have to be so serious that basically he wouldn't have been functioning at the level of a counsel that's guaranteed by the Sixth Amendment. Nothing here has been demonstrated by the defense that that happened. And that applies for count 2 as well. Nothing in the record would even indicate that the sentencing judge had any indication or inclination to want to downward depart. He took every opportunity he could to enhance the penalty. Even when counsel was saying, please don't give him the 10-20 life, here's why. Here's reasons why. He ran them consecutive. First DCA says, don't do that. So he didn't lower it. He just said, okay, I'll run them concurrent. There is nothing today has been shown that there would be a reasonable probability that the outcome would have been different if any act or omission that Attorney Derham committed would have happened. That would have been even, I guess, what's the word? He would be deprived of a reliable result. Nothing shows that that would have been reliable. That it's pretty reliable. If this would have happened, that sentence would have been less. It wouldn't have been what he got. If anything, it shows that the sentencing judge was not, the evidence was overwhelming in the case. It was all on video. This case, this was a very extreme situation that was explained to the defendant. And then he actually had a letter. He said, look, I just need you to know this is what I'm recommending you do. This is a good deal. and I need you to sign this so you understand what we're dealing with. This lays it out. So it's established that Mr. Durham informed his client, Mr. Wanless, of what he was facing. He also informed him what the state was willing to do to offer a plea bargain. And then he had the full knowledge of what the decision was, and he advised him, you should take the deal. He read it out loud. This is to inform you that my advice to you is to accept the offer from the state attorney in this case number. So and if we're going to go there as far as what the intent of that statute, the legislators that drafted it told you what their intentions were, and their intentions were that the trial court would find written findings of all four of those things because it's a certain situation that they wanted to carve out. An aggravated assault when there was reasonable justification, that they had legal justification to do so. That was the whole point. And at no time was this case ever about stand your ground or legal justification to commit an aggravated assault with a firearm. So that's
Thank you,
state's position.
Mr. Love?
Just briefly, Judge, I know it's past 5 o'clock and I feel sorry for all the staff here and yourself, Judge, but I'm just going to briefly make this argument of 4 points. One, the state attorney said, trial counsel asked me how long I'm going to keep this open for, and I know I'm going to keep it open until the docket day, and then the state attorney who made that statement said on the following docket day, Judge, I want to colloquy him on the offer, because he knew that was the day. Judge, colloquy him, does he want it or not? The second thing I want to mention is Alcorn, Judge, which the important issue in Alcorn is what Mr. Wanless knew at the time he made a decision. And that's why I highlighted that whole date calendar of events from the 17th to the 23rd. And then the 4 prongs, just to remind Your Honor, is 1, Mr. Wanless would have accepted the offer had he been properly informed. 2, the state would have not not had foreclosed the offer at that time. 3, the court would have accepted it, and that's mostly if the court's silent on the record. Had the court said, no, I'm not taking an offer in this case, then it would have been foreclosed. And 4, it's less severe. 5 years is more than the 48 and 20 and the 20 that he got. And then as far as when the state talked about the legal burden to find ineffective assistance at counsel, on each point that we made as far as the misadvice or lack of advice Mr. Wanless got, if you go back in our motion, Judge, we cite specific case law that says ineffective assistance can be found on any one of these grounds independently, and there's case law to back each and every one ground. So it's not in the whole course of practice. A trial attorney can make one mistake, and that can lead to being ineffective. And the last thing I'll mention, Judge, is the letter. I think from Mr. Diadram to Mr. Wanless, to me, that exemplifies our whole argument. There is no explanation of the facts to Mr. Wanless. It's, here's the offer, you should take it, and there's the 1020 life. That's it, you know. What makes a client susceptible to understanding what's going on is the breakdown of the facts and the evidence and the law, and an attorney's experience on how that all comes together so that they can make an informed decision. And I believe this bare minimum layout is not sufficient. And I think that's what he got at the time, not because Mr. Diadram was doing anything, you know. It was a product of he couldn't do it because of the Richardson hearing and the state not disclosing the appropriate information during the time the plea offer was available. Thank you.
Thank you.
I just have
No, sir. There's got to be an end. Mr. Weinmeister, I would like nothing more than to rule right now and give you closure. But if I did, I know that my decision wouldn't be as good as me taking it under advisement, looking through everything, listening, going through my notes and comparing it to what's in writing. So I'm going to take it under advisement. I hate things being on my desk. I hate the ball being in my court. So I'll rule on it as quickly as I competently can. And then I'll send it to your attorney and also the state.
Yes, sir.
Okay?
Thank you, Your Honor.
Thank you, sir. Thank you. Do we have any
Thank
other
you,
hearings?
Judge.
Is that Mr. Arrowwood's? Okay, so Mr. Arrowwood was sick